pleased to welcome all of you to our law school. We are honored to host again the Justice Prize of the Peter and Patricia Gruber Foundation. 2 years ago, we had the pleasure of hosting the ceremony when the Gruber Justice Prize was bestowed on one of our colleagues, Tom Bergenfeld, who's there in the front row, who was then a member of the International Court of Justice. He's returned now to our faculty, and also Jeremy Shastak, the former president of the American Bar Association. Today's ceremony recognizes two individuals and one institution that have championed justice through their words and their deeds. Their work has reshaped the law at the institutional level and has had a profound and lasting effect on many individuals. We're honored to have with us the distinguished recipients of the 2010 Gruber Justice Prize, Justice Michael Kirby, retired of the High Court of Australia, Professor John Dugard of the University of Pretoria and formerly of Leiden University, and also the Indian Law Resources Center. We're humbled by your presence and your lifelong commitment to improving mankind in the face of adversity and criticism. We're also delighted that Justice Arthur Chaskalson, of the former Chief Justice of South Africa and former President of South Africa's Constitutional Court, can be here. And of course, we're grateful to the Peter and Patricia Gruber Foundation for its support of the Justice Prize, as well as for its support of many other activities that have helped institutions and individuals better understand and apply legal principles and promote reasoned justice. Now it gives me great pleasure to introduce Patricia Gruber, who will award the prize to the 2010 recipients.
Thank you, Dean Maggs. Welcome to the presentation of the 10th Annual Gruber Justice Prize. The Justice Prize honors individuals who have advanced the cause of justice as delivered through the legal system. We are delighted to return to George Washington University School of Law, an institution that is committed to engaging the world from this nation's capital, and a most fitting place to present this year's prize. We're here to honor three recipients: Michael Kirby, John Dugard, and the Indian Law Resource Center, for safeguarding human rights and helping make equal justice under law a reality for groups that historically have been victims of systemic discrimination. Please let me tell you a little about the company they are keeping. The Foundation's prize program, established in 2000, now presents 5 annual $500,000 prizes in the fields of cosmology, genetics, neuroscience, justice, and women's rights. Each prize recognizes achievements and discoveries that produce fundamental shifts in human knowledge and culture. On September 21st, the Women's Rights Prize was presented to the Center for Reproductive Rights and CLADEM at the New York University School of Law. This Friday at the University of Chicago, the Cosmology Prize will be presented to Charles Steidel. In November, the Genetics Prize will be presented to Gerald Fink at the 60th Annual Meeting of the American Society of Human Genetics, again in Washington, D.C. And later in November, the Neuroscience Prize will be presented at the 41st Annual Meeting of the Society for Neuroscience in San Diego to Robert Wirtz. I'd like to acknowledge the vision and leadership of my dear husband, Peter Gruber, who cannot be with us today, in establishing these prizes. Although we worked together since inception, it is Peter who earned the money and who had the vision for this prize program. The Justice Prize is especially dear to Peter's heart because, as many of you know, being Jewish, his family escaped Hungary during World War II and fled to India. Soon after their arrival, Calcutta was bombed by the Japanese. His parents, again fearing for the children's safety, sent Peter and his brothers to the Himalayas for their education. With regard to this prize, Peter's words were that he wanted to establish a prize for justice as a means of redressing the arbitrary use of power. As this came directly from his own personal experiences, he is especially appreciative of each of today's individuals' efforts to uphold these values. Sadly, due to his health, he's not able to be with us today, but he wanted me to convey his most sincere congratulations to all three of you. And now back to the previous laureates of the Justice Prize. They include Brian Stevenson and the European Roma Rights Center, Thomas Bergenthal, who is here with us today, and Jerome Shestak, Carmen Argibay, Carlos Cerda, and Monica Feria, Aharon Barak, Param Kumaraswamy, Arthur Chaskalson and Pius Langa, Rosalie Silberman Abella and Bertha Wilson, Fali Sam Nariman. And the initial prize went to Anthony Roy Gabe and the Law Society of Zimbabwe. This year's recipients were chosen by a distinguished advisory board comprising Carmen Maria Argibay, Arthur Chaskalson, Param Kumaraswamy, Bernice Donald, Robert Cushion, and Ramon Mullarat. Peter and I deeply appreciate the knowledge, the commitment, and the enthusiasm that these advisors bring to the judging process. We would like to thank the George Washington University School of Law for hosting the Gruber Justice Prize this year. Dean Lawrence graciously agreed to host us, and Dean Maggs agreed to welcome us. And the GWU law staff went to great lengths to make this event a success. I would now like to present Ramon Mullarat, here from Barcelona, Spain, where he is a practicing lawyer. Mr. Mullarat is a former president of the Council of the Bars and Law Societies of the European Union and was co-chair of the Human Rights Institute of the International Bar Association. He is an advisor to the Justice Prize. He will read the prize citation and briefly present Michael Kirby. Ramon Mullarat.
The 2010 Justice Prize of the Peter and Patricia Gruber Foundation is proudly presented to Michael Kirby, John Dugard, and the Indian Law Resource Center for contributions to international law and the advancement of human rights and rule of law. Michael Kirby has defended victims of unjust regimes and promoted the cause of international human rights, including in particular law relating to privacy, data security, bioethics, and HIV/AIDS. Active in law reform at home and abroad, his work has had an impact on the legal culture of many countries. John Dugard, respected worldwide for his courage and scholarship, has championed the development of international human rights law. Having challenged the injustice of apartheid law from within South Africa, he participated in the constitutional negotiations leading to the adoption of their human rights-based constitution. For over 30 years, the Indian Law Resource Center has exposed human rights violations against indigenous peoples in the Americas, using international law to assert their claims. The Center was a leading participant in the adoption of the United Nations Declaration on the Rights of Indigenous Peoples. And now it is a great honor and pleasure to introduce Justice Kirby. The Italian jurist Piero Calamandrei, in his delicious Elogio di giudici scritto da un avvocato, said, fra tutte le professioni che i mortali possono esercitare, nessun'altra possa meglio giovare a mantenere la pace tra gli uomini di quella dei giudici, che sappia essere puro dispensatore di quell'alimento d'ogni ferita che si chiama giustizia. Among all the professions that mortals can exercise, no other can best assist to keeping the peace among men than that of the judge, who knows to be a pure provider of the liniment of all injury, which is called justice. Michael Kirby was born in Sydney and educated in 4th Street Boys High School. He holds the degrees of BA, LLM Beck from Sydney University. Justice Kirby practiced as a solicitor and then as a barrister before his appointment in 1974 as a Deputy President of the Australian Conciliation and Arbitration Commission. He served as the inaugural Chairman of the Australian Law Reform Commission. In 1983, he took up appointment as a Judge of the Federal Court of Australia. He relinquished that post in 1984 on his appointment as President of the New South Wales Court of Appeal. In 1995, he was appointed to the post of President of the Court of Appeal of Solomon Islands. He resigned these positions when he was appointed in 1996 as one of the 7 justices of the High Court of Australia, Australia's Federal Supreme Court. Justice Kirby has had a long connection with universities. At Sydney University, he was elected President of the Students' Representative Council and of the Sydney University Union. He served as Fellow of the Senate of Sydney University and as Deputy Chancellor of the University of Newcastle. In 1984, he was elected as Chancellor of Macquarie University in Sydney. He served on the Administrative Review Council of Australia, on the Australian Council of Multicultural Affairs, and on the executive of the Commonwealth Scientific and Industrial Research Organization. In 1978, Michael Kirby commenced involvement in international activities. Between 1995 and 2005, he served on the International Bioethics Committee of UNESCO, chairing the group that prepared the Universal Declaration on Bioethics and Human Rights, which was adopted by the General Conference of UNESCO. He also served on the Ethics Committee of the Human Genome Organization and as a member of the inaugural Global Commission on AIDS of the World Health Organization. In 2002, he chaired an expert group convened by UNAIDS and the High Commissioner for Human Rights on HIV/AIDS and human rights. In 2001 and 2002, he was chairperson of the UNAIDS expert panel on HIV testing of United Nations peacekeeping operations. Since 2004, he was member of the UNAIDS Global Reference Panel on HIV/AIDS and Human Rights. Michael Kirby was a member of the Executive Committee of the International Commission of Jurists, rising to be chairman and later president of the ICJ. He was appointed by the International Labour Organization as a member of the Commission on Freedom of Association. Between 1993 and 1996, he served as a special representative of the Secretary General of the United Nations for Human Rights in Cambodia and as independent chairman of the Constitutional Conference of Malawi. In addition to these activities, Justice Kirby has served in educational institutions such as the International Advisory Group on Advocacy Training of the Inns of Court School of Law in London, the Board of Governors of the Kinsey Institute with Indiana University, and the Advisory Board of the International Human Rights Institute of DePaul University in Chicago. Currently, he is rapporteur of the International Group on Judicial Integrity, which prepared guidelines on judicial integrity endorsed in 2006 by ECOSOC and now under the aegis of the United Nations Office on Drugs and Crime. Justice Kirby has received a number of honors. These include the appointment as Companion of the Order of Michael and St. George, and as a Companion of the Order of Australia, and he has received the honorary degree of Doctor of Letters from the University of Newcastle, the University of Ulster, and James Cook University. The honorary degree of Doctor of Laws from Macquarie University, the University of Sydney, the National Law School University of India, Buckingham University, and the Australian National University. He was also awarded the honorary degree of Doctor by the University of South Australia and the Australian Human Rights Medal. In 1998, he was named laureate of the UNESCO Prize for Human Rights Education. In 2005, the Sydney Morning Herald named him as one of Australia's top 10 public intellectuals. And in 2006, the Bulletin named him as one of the 100 most influential Australians ever. He has been elected as honorary member of the American Law Institute and as an honorary bencher of the Inner Temple in London. He was awarded the Prix Yves Pelissier of the International Academy of Law and Mental Health and the Lifetime Achievement Award of the Australian Law Awards. A great American justice, Oliver Wendell Holmes, said once that, I quote, "The life of the law has not been logic, it has been experience." If this is true, Michael Kirby, in his outstanding legal and justice pilgrimage, has exceptionally contributed to the expansion of law. One aspect stands out of Michael Kirby's multifaceted nature, and it is his humanity and his preoccupation for human rights in the defense of the millions of people suffering in this world. Kirby said once that, I quote, "To be human is to feel the pain of brothers and sisters everywhere. Feeling that pain, we must each do whatever we can to build a better world." Human rights is the political slogan of our time, but paradoxically, the gap between glossy declarations and the reality is enormous. René Cassin, one of the drafters of the Universal Declaration of Human Rights, said, "Il n'y aura pas de paix sur cette planète tant que les droits de l'homme seront violés en quelque partie du monde que ce soit." We lawyers have a special obligation in this battle. Another justice, an American Justice William Brennan, referred to, I quote, "the higher calling of the law," meaning the special obligation of lawyers to become involved in the overriding concerns of society. We lawyers, we are 6 million in the world. All of us one day, in different places and languages, we swore to fight for the rule of law and for justice. If this team could act in concert, there would be little that we could not achieve. We could honor our oath and could make this world a little better place. As Antonio Machado, the Spanish poet, said, "Se hace camino al andar." The way is made by walking. Justice Kirby has walked a long way. Thank you very much.
Thank you, Mr. Mullarat. I will now call on another advisor to the Justice Prize, Robert Coulter, to present our second and third recipients. Mr. Coulter is the Managing Director of the European Roma Rights Center, has been active in the human rights field in Eastern Europe and the former Soviet Union, as well as in the areas of health, human rights, and development. He has served in the Office of the Legal Advisor of the U.S. Department of State and as liaison to the International Criminal Tribunals for Yugoslavia and Rwanda. Robert Coulter.
Thank you. Thanks very much. First, I have the honor of introducing Professor John Dugard. When I was asked to do this, my immediate instinct was to panic at the thought of reducing the brilliant career of this man to a 2-minute soundbite, but I'll do my best. My second instinct was to plagiarize. And if you look at the nomination materials that were submitted for Professor Dugard, I think it sums it up very nicely. His nominees, who were colleagues in academia, said of him, Professor John Dugard has advanced the cause of justice as a teacher, scholar, advocate, activist, UN rapporteur, and judge. His most important achievements relate to the advocacy of human rights and humanitarian law in 3 controversial areas: South Africa, Southwest Africa, Namibia, and the occupied Palestinian territories. He's regarded by many as the father of human rights in South Africa. That was only 40 seconds. Great. So we're doing well. The subject matter that he's covered in his career is vast, ranging from attacking the legal underpinnings of apartheid, fighting against the death penalty, supporting independence in Namibia, and advocating against human rights abuses in Palestine. Professor Dugard presently is at the University of Pretoria. He's served in many academic positions. Prior to that, as has already been noted, chair of public international law at Leiden University. He's been an ad hoc justice on the International Court of Justice, a special rapporteur to the United Nations, member of the International Law Commission, the author of several books and over 100 law review articles. These are, without a doubt, a very impressive array of professional achievements. But I also wanted to note that we honor Professor Dugard for his common sense which has been honed in the realities of his homeland. Professor Dugard understands that the real politic of peace and reconciliation, and I just want to quote from his 2008 report to the Human Rights Council on the situation of human rights in occupied Palestine. And I'm going to just take a little editorial license and switch the words around a little bit, the order anyway. He wrote, Israel cannot expect perfect peace and the end of violence as a precondition for the ending of the occupation. That is why every effort should be made to bring the occupation to a speedy end. Until that is done, peace cannot be expected and violence will continue. Now, for those who support Israel, as do I, this may be an uncomfortable truth. But it's the job of a human rights advocate to articulate uncomfortable truths. And it's a prerequisite to the pursuit of justice. And the pursuit of justice, after all, is what the Gruber Prize is about. And it's for this pursuit of justice that we honor Professor John Dugard today. Thank you. Let me say now a few words about the Indian Law Resource Center, the final recipient of the Gruber Justice Prize today. This organization and the theme, I think, was new to the nominating committee and provoked some very interesting discussion. But in the end, without hesitation, that the committee decided to award the Indian Law Resource Center this prize. This is an organization that champions the interests of indigenous people, primarily in the Americas, although the work of the organization has precedential value throughout the world. The Indian Law Resource Center has exposed human rights violations against indigenous people in the United States, in Latin America, in South America, and rights violations in some of the most impoverished and vulnerable communities in the world. It's helped to develop skills within these communities so that they can know and protect their own rights. And the center has engaged in a lot of novel legal activity in a long-term effort before the United Nations to ensure the passage of a Declaration on the Rights of Indigenous Peoples, which finally occurred in 2007 after its inception 30 years before. And just as an aside, when I was working in the legal advisor's office at the State Department, the declaration at that time, the draft declaration on the rights of indigenous peoples, was viewed with great nervousness. It was something that we were always dancing around, and I was both in Republican and Democratic administrations, and everybody was equally nervous. And I could say that that's probably a point of honor for the Declaration. There's an inverse relationship to its progressive nature and the degree to which it makes lawyers in the State Department nervous. And in the 1990s, it seemed rather, our nervousness was calmed a bit by the fact that it seemed rather inconceivable that this declaration was going anywhere. But I'm happy to say that the declaration was adopted by the General Assembly, and that the Indian Law Resource Center and Tim Coulter, its director, deserve a lot of credit for that as being the inspiration and behind it, and Tim Coulter himself is one of the original drafters. The Center has also brought cases before the Inter-American Commission, the Inter-American Court of Human Rights, using international law to assert claims on behalf of indigenous communities, particularly claims to land and to resources. And again, in the context of the United States, this is somewhat novel activity, but important activity. And as Tim Coulter mentioned in one of his articles a few years back, he recognized the limitations of using international law instruments, particularly in the U.S. context with indigenous people here. But he also noted that the politics of international law have palpable force among governments, including the United States. And so I think it's important to recognize that the pursuit of justice also involves the playing of politics when necessary, and that international law and politics in this sense are intertwined. I want to just close with another quotation from the mission statement of the Center, because I think it sums up very well what the organization is about. And the quote is this: "When any culture ceases to exist, the whole world is irrevocably diminished. And it's the job of the Indian Law Resource Center to use the rule of law to preserve human rights and dignity of all human beings, in particular of indigenous people." And it is for that work that the Gruber Foundation awards the Justice Prize, in part to the Indian Law Resource Center. Thank you.
Thank you, Mr. Cushion. We'd like to invite all three recipients to come forward to receive the prize. It's now my pleasure to present today's moderator for the panel discussion with the prize recipients, Justice Arthur Chaskalson, also a Justice Prize laureate and advisor currently to the Justice Prize, and he serves as the chair of the selection committee. Justice Chaskalson was appointed the first president of South Africa's new constitutional court by Nelson Mandela in 1994, and was Chief Justice of South Africa from 2001 to 2005. In addition to the Gruber Justice Prize, he has received the award of Supreme Counselor of the Baobab, Gold, and the Nelson Mandela Award for Human Rights and Health. Justice Chaskalson was president of the International Commission of Jurists, was the first chairperson of the South African Judges Commission, and chaired the eminent jurist panel appointed by the International Commission of Jurists to inquire into the impact of terrorism and counterterrorism on the rule of law, human rights law, and where relevant, international humanitarian law. Judge Chaskalson. I'm so sorry, I made a mistake, and I haven't given the recipients the opportunity to make a few brief comments. So I'm going to suck the words back in and ask our recipients to come forward and make a few remarks. Thank you.
I had half an hour of remarks ready to express, and I thought I'll never get a chance to say this, but I would have worked it into my speech from the bench. Judges have sometimes been known to do that. Patricia Gruber, Ramon Mullerat, Robert Coulter, Associate Dean Maggs, and dear friends who are here. This is a moment for a few acknowledgements. I want to acknowledge the presence of Judge Fable, Judge Bergenthal, my dear friend Justice Lheureux Dubé, who's come specially today, Professor Robert Post of Yale Law School, Professor George Smith of the Catholic University here in Washington, and many other friends who are in this audience. I acknowledge the assistance I've had throughout this process from Patricia Gruber and the staff of the Gruber Foundation, who are entirely professional and very efficient in the way they prepare for these important prizes. Let me acknowledge also, as all of us would do in our mind, our original teachers. In my case, it's Miss Pontifex. Miss Pontifex, so well named, who taught me how to read the alphabet back in immediate post-war Australia, back in 1945, at the North Strathfield Public School. Great are the nations that have strong public education, and we in Australia have been blessed with that and must always defend it. At university, Professor Julius Stone, who taught me the realism about the law and to put aside the myths. My colleagues in the judiciary over 34 years, who taught me every day I sat with them. Fortunate is a nation that has judges who are uncorrupted, and I can say, as I laid down my judicial robes, that never once in that 34 years was any attempt made to corrupt or subvert the course of justice in my country. As we know, that isn't true of every country in the world, and the Gruber Justice Prize is an inspiration that we should build that form of rule of law society. Rule of law, law but just law in every country on earth. I acknowledge my colleagues who are here with me. We stand shoulder to shoulder in our different spheres. I, as a full-time judge over 34 years, Professor Dugard as a teacher for so many of us, including for myself in Australia, and Tim Coulter in his marvellous work for Indigenous people, which has also been a source of inspiration and lessons to us in Australia, where we haven't, as you'll hear in the panel session, always been on the right track of Indigenous rights. I acknowledge my family, my marvellous mother with her perception, my father, who is still alive. Actually, he's still driving, and he takes no nonsense from his children, whom he welcomes on Sundays. He's very strongly into vegetarianism now, and he's always teaching his children new tricks. It's appropriate also that I acknowledge my partner, Johan van Vloten. 41 years and a half he has put up with me. And it's important that I should say that to you, 41 years and a half. If anyone in this audience has any problem with that, though I suspect there aren't any or many here who would, they've got to get over it. It's simply part of the reality of this world. I came here last night from Sao Paulo, where I was working with a new global commission on HIV and the law. And I go from here to a conference in Pattaya in Thailand on sex workers and the law. And some people might say, what's an I-sex judge like you doing mixing with a group like this? Well, we're mixing with them because their human rights are not always respected. And in particular, the GLBT, the gay people of the world, whose human rights are not always respected and protected. And that is not only an affront to human rights, it's a serious imposition on the struggle of the world against the HIV/AIDS epidemic. So today in this great country is Columbus Day. As with our Foundation Day in Australia, which marks the arrival of Captain Cook, it is a somewhat ambivalent celebration. And I understand it's a day which the indigenous people, or some of them in this country, describe as the day for indigenous rights. And similarly, I was told this morning, it's coming out day for some people in the United States. So that, again, brings together the three recipients of the 2010 Gruber Justice Prize. We're all coming out. We're all coming out to a recognition of justice for all, equal justice under law for all, which is carved on a mighty building in this city, but sadly has not always been the truth either in the United States of America or in my own country or in South Africa or even worse in many other countries of the world. So I want to tell Robert Coulter that my hope is that we will move in the not too distant future to an international convention for sexual minorities, and that will really upset some people in the State Department, and that would be the criterion for a very good thing. Thank you very much for being here today. Thank you for my friends being here.
Thank you very much. Well, let me begin by expressing my gratitude to the Peter and Patricia Gruber Foundation for conferring the 2010 Justice Prize on me. I'm greatly honored by this award, and I'm delighted to be in the good company of Michael Kirby and Tim Coulter of the Indian Law Resource Centre. And thank you, Robert Coulter, for the kind words that you said about me. I would also like to thank my wife, Itya, who is here today, for all the support she has given me in what one might describe as the struggle for justice. During the early days when I was Special Rapporteur on the occupied Palestinian territory, I decided that I would relinquish my position because I was simply overstretched. And Itya encouraged me to continue. She insisted that I continue. She traveled with me to the occupied Palestinian territory when I went on mission. She witnessed many of the injustices that I witnessed, and she was always supportive, even when I was vilified for my reports, and I want to thank her in particular. I want to thank family and friends who are with me today, Jackie, my daughter, and her partner, Tumi, Dennis and Patty. Dennis Herbstein and I have been partners in the struggle for many years, Dennis as a journalist and I as a lawyer. Jackie is a relative newcomer to the struggle, but she has already made her mark as a legal activist in the field of the promotion of social and economic rights. And I'm delighted to have old friends with me here today, particularly Arthur Chaskalson, with whom I worked for many years in South Africa, Tom Bergenthal, good friend from The Hague, with whom I've sat on the International Court of Justice, and Hussein Hassouna, with whom I now sit on the International Law Commission, but our friendship goes back many, many years. I simply wish to say that when I use the term struggle, I do not refer to the struggle for power or for liberation. I talk about the ongoing struggle for justice. This is a struggle that encapsulates many causes, because injustice is all pervasive. No country is spared its injustices, although some suffer more than others. In my life, I have addressed injustices in South Africa, Namibia, and the occupied Palestinian territory. I hope that I have helped, albeit minimally, in advancing the cause of justice in these countries. I think I've been more successful in Namibia and South Africa. But there's much to be done. There are many dimensions of injustice, ranging from torture to poverty and denial of due process of law to denial or suppression of free speech. And many are engaged in the task of confronting injustice. So today I accept this prize on behalf of many who are active in the struggle for justice, who are unacknowledged. I accept in full awareness of the fact that there is much still to be done. The Gruber Prize, as I understand it, is designed to encourage those engaged in the struggle for justice and against injustice, and I'm proud to receive this award today. Thank you very much.
On behalf of our whole staff and board, and I would like all of you to stand. Please do it. Please stand, because it's this. No, I want to recognize that this award is for the whole Indian Law Resource Center, and I'm just here in their behalf. I'm happy that very nearly our entire board and entire staff is here today. From all of us, thank you to the Peter and Patricia Gruber Foundation. You're wonderful to promote justice in this way. It's awfully important. The Indian Law Resource Center staff and board, well, they do deserve this prize. All of you have done magnificent work. It's a very capable group, and I just have the privilege of speaking in their behalf. I'm very happy too that the Ford Foundation is represented here today by my friend Sara Rios. The Ford Foundation has been a great supporter and partner and friend. Other foundations and contributors have been extremely important also. The Lannan Foundation and my late friend. Well, I wasn't going to do this. A good friend, John Lewis, was very generous and very active in our work. Sadly, he is no longer with us. But these funders and supporters are a part of the organization, and they're crucial to what we do. The Peter and Patricia Gruber Foundation is really wonderful to recognize what we've been doing these last 33 years, and I'm also very honored and awed to be in the company of John Dugard and Michael Kirby and Tom Bergenthal, and so many others that are here today. I must also remember, and I am remembering, to thank the Indian and Alaska Native nations that we serve. They don't get any prizes, and yet they fight for these same things. They suffer for these same things all the same. We merely try to help them. I think of the Yanomami in Brazil, the Onondaga Nation, the Tonawanda Seneca Nation, the traditional Seminole people, the Hopi, the Oglala Lakota, the Inupiaq people in Alaska and northern Canada, and so many others. They are all a part of it. We are a part of them, I suppose. Well, we have a great deal left to do, and that's in a way good because we're ready to do it, and we're going to dedicate all of this prize to carrying on the work, and so I thank you once again very, very much.
Thank you, and now our distinguished moderator will begin the panel discussion.
Well, good morning to you all. We have today three exceptional people who are laureates and who come from three different continents. And so and their life, their work has been concerned with human rights, with the promotion of justice, with the promotion of the rule of law. You've heard all about it, and they are quite extraordinary persons. And so the topic which they have been asked to talk about today is an appropriate one because it concerns the use of human rights to promote the interests of communities. It's the use of international human rights law by domestic courts. And as we have people from different parts of the world, it is right that we should have an international flavor to our discussion. It all goes back really to the second half of the last century when the adoption of the United Nations Charter and the Human Rights Instrument which followed led to a development of a concept of human rights in many different fields and an acknowledgement of it and an acknowledgement of its international component with a trade of ideas between different countries and a trade of ideas between people working in that field, between judges and lawyers and academics and politicians. And with the use of the internet and globalization, that exchange has become more profound and it's beginning to affect domestic courts in many parts of the world as judges start thinking about issues which are the same in many different parts and which express themselves the same in their own societies, and therefore we can each learn from the other. And so the topic is an appropriate one, and the order we have agreed upon amongst the three laureates is that Michael will start, Tim Coulter will follow, and then we'll have John Dugard. So, Michael, will you please begin?
Yes, as Marcella, the poet, said, and we were told of him by Ramon in his introduction of me, life is a journey, and I want to tell three little stories of my journey in relation to this issue. Back in my university days, I had, as I said, a great teacher of jurisprudence and international law, Professor Julius Stone. And he taught me the orthodox view, at least the orthodox view in common law countries, that international law was up there in the clouds about princes and kings, and national law was down there on the ground, and rarely did the universes meet. And that was the orthodox view about dualism of the two legal systems. But then in 1988, I went to a conference. It's a very good thing for judges to go to conferences, especially with legal scholars. The conference was held at Bangalore in India. It was chaired by the then recently retired Chief Justice of India, Justice Bhagwati, and one of the judges attending was a very young American judge who was then on the DC Court of Appeals, by name Ruth Bader Ginsburg. And the lesson that was taught at this conference was that in the modern age, when you look contextually, one of the things that is happening all the time is the growth of international law as statements of a conceptual kind that deal with the fundamental rights of all of us as human beings. And so I had an epiphany, and I went back to my central seat in a bench in a courtroom rather like this, sitting in Australia, in Sydney, in the busiest appellate court of Australia, and I began to get cases where this instruction was actually quite helpful. And one of them was a case of a judge, a very good judge, who had refused to allow interpretation from the mute language in court, although the court remained open. And he had said this was only on a legal matter, so there was no reason to interpret. A disempowerment of the mute applicant. And so they rushed up to the Court of Appeal, and we were very user-friendly, so we interrupted the boring case we were dealing with, and we then asked them to develop the argument. And they couldn't point to any constitutional provision in Australia. They couldn't point to any statutory provision. And the common law simply said giving an interpreter or not is a matter in the discretion of the judge. And you don't normally interfere with trial judges' discretions. So we went off, the three of us, into my chambers, and I thought Bangalore. And so I reached for the International Covenant on Civil and Political Rights, and in that covenant there's a specific provision that if a person needs an interpreter, the interpreter should be provided. And so I used that as a basis for adopting in the common law of Australia a principle that was informed by the international concept. That was regarded by a lot of judges and lawyers as sheer heresy. They were very upset. They wouldn't have been upset in most countries of the world, but in Australia and the United States, they were nodding their heads gravely. However, about 4 years later, in 1992, in the great case in the High Court of Australia, to which I hadn't at that time been appointed, the decision was made in Mabo. Mabo was the case about Aboriginal land rights. And in the way of recognising land rights for the Aboriginal people in Australia was 150 years of land law and decisions of the Privy Council and of the High Court of Australia itself. But the way the court overcame all that body of legal doctrine was to say, if that is the common law, the one thing that is clear from international law today is that you cannot discriminate against people on the basis of their race. And so the High Court of Australia, by 6 justices to 1, we are 7, decided that it could unlock the door to re-express the common law by reference to the international principles of human rights. So it was a very important decision for the Indigenous people of Australia, who are often treated very poorly in the Australian legal system. It might have been uncorrupted, but it had rules which were very poor, something like South Africa. So the third story is that during the rest of my life, including on the High Court of Australia, when cases would come up, we would refer to international human rights. And just before I left the court in 2007, we had a case about prisoners' rights and about the rights of prisoners to vote in elections. And by reference to a decision of the Canadian Supreme Court in which Justice Dugard took part, Sauvé and the Queen, and by reference to a decision of the European Court of Human Rights in Hurst against the United Kingdom, we upheld the right of prisoners to vote in the national federal elections in Australia and said that was constitutionally protected. And we interpreted our constitution by reference to these decisions. And I learned this morning that Chief Justice Chaskalson signed an opinion in the Constitutional Court of South Africa, which wasn't referred to us, which said the same as Sauvé and Hurst, which all goes to show that this is a growing body. It's a conceptual body. It doesn't bind you. It's not law, but you can use it as a source of inspiration, of information and of context in understanding your own national law. So they're the three little stories of my journey in my judicial life, and I believe it's a journey that all courts of this world will take and are taking. It was taken in the United States in Lawrence, the important case on gay rights, and it will help us to avoid error and to be inspired by the stories of people everywhere.
Jim, can you follow?
Well, yes, that's a very nice lead-in to some comments that I would like to make. Dawn may be breaking in the United States, but generally speaking, the way is untrodden so far as changing the law that is so discriminatory against Indian and Alaska Native peoples. It's astonishing but true that the United States Supreme Court holds that the United States government is free to confiscate Indian and Alaska Native land at will without due process and without compensation. And the government does do that. They will confiscate Indian money belonging to Indian tribes. They'll confiscate it right out of the U.S. Treasury with no compensation, no due process of law, nothing. And it's based entirely on race and ancestry of the people constituting these Indian and Alaska Native nations. It's astonishing that this kind of thing could persist in the United States, but it does. It's wholly contrary to the United States Constitution, certainly contrary to the fundamental human rights principles of international law. There's more, sadly. Federal law places Indian and Alaska Native nations in a state of permanent and involuntary trusteeship without any serious accountability. Well, no one else is treated like that except for children and people who are mentally incapable. But Indian nations and Alaska Native nations are treated that way, and for the most part they have no legal recourse. Treaties or contracts can be made with Indian nations by the United States government and violated mostly at will without any legal redress. Again, it only happens to Indian nations. The law doesn't permit it as regards anyone else. The United States government claims that it has plenary power to do as it wishes with Indian nations and their property and resources without regard to the United States Constitution. There's no one else in the borders of this country, or even without, to whom, or with respect to whom the United States government claims such a power. Well, what I'm getting at is that we need to see a breaking of the dawn in the United States courts about human rights and about the relevance of human rights instruments, including the ones the United States has ratified. The United States law is, like many countries that follow the tradition of the British Commonwealth, the United States certainly ratifies international human rights instruments, but most such treaties are not self-executing. In other words, they are not a part of our domestic law that must be applied in the United States courts unless there has been action by the United States Congress to implement those obligations. Nevertheless, as the Supreme Court said, international law is part of our law. Early in this country's history, the Packet-Habanya case announced that. International law is part of our law and will be applied by the courts in proper cases. The trouble is that the courts, through their own decisions, have undermined the actual application of international human rights law. But we have the Charming Betsy case. That's the name of a schooner, Charming Betsy. It's always nice to enjoy little things like that, like this beautiful day. Dark things that we talk about, but there's a lot to enjoy anyway, isn't there? Well, the Charming Betsy says that United States statutes will be presumed to be intended to be applied and interpreted consistent with international law, not the opposite. And as has already been suggested, the United States courts do not ignore international law. In fact, there are 6 cases that the Supreme Court has decided in the last, well, it's less than a generation, in the last several years, that take international standards, international human rights into account in determining decisions they make about United States law. There's Atkins v. Virginia regarding execution of persons who are mentally retarded, Lawrence v. Texas concerning anti-sodomy statutes, Gruber v. Bollinger about affirmative action, particularly in education. In all of these cases, international standards, international law and concepts were employed. And there's more, Roper v. Simmons concerning the death penalty for convicted criminals under the age of 18, the recent Hamadan v. Rumsfeld concerning war crimes tribunals, and finally a more obscure case under the sovereign immunities, the Foreign Sovereign Immunities Act. The Supreme Court is quite right to do this. They do and they should employ international law and human rights law in the decision of cases, but more needs to be done because the United States is in fact bound by international law, particularly international human rights law, customary law, and the treaties the United States has ratified, and regardless of our domestic law in the country, but nevertheless bound by international law. Well, the United States is reviewing its position today on the Declaration on the Rights of Indigenous Peoples. Secretary of State Clinton has announced at another law school here in this city that the United States intends to resume a leadership position in regard to human rights, that it will hold itself accountable, that it will be an advocate for human rights, and that it will expect other countries to do so. I think this administration is at least mostly genuine when they say such things. But there's been a good deal of talk, not much action so far, some, and it is likely that the first official action that the United States government could take is to be the endorsement of the United Nations Declaration on the Rights of Indigenous Peoples. The United States voted against it in the General Assembly. That was under the previous administration. This one has said they are reviewing it entirely. There are 15 government agencies engaged in that review. This is a good time to speak up if you know anyone or want to send an email. Do so. You can go to our website, www.indianlaw.org. There's never a chance that I'm not going to be an advocate, but we do need to advance the rule of law. We do need to get this country moving in the right direction about human rights and to change its law about indigenous peoples. So this prize, I think, is a help in moving that forward, and I'm grateful that I have this chance to say that the Mabo decision can help us lead the way, can help us, it does lead the way.
Yes, thank you. I want to address two issues affecting the relationship between international law and domestic law. First of all, relating to my South African experience, and secondly, dealing with an issue affecting the United States. First of all, as far as my South African experience is concerned, during the apartheid years, it was heresy to invoke international human rights norms in domestic courts. I recall a case in which I was involved, in which the issue was the question of separate areas zoned for different racial groups, which was a zoning system that was applied in a very discriminatory manner. And when I attacked the validity of the legislation setting up the scheme, I referred to the United Nations Charter, which prohibits discrimination based on race. And I recall that the prosecutor jumped up immediately and said, Lord, to the judge, my learned friend is being political. This is a purely political issue, and the judge ruled me out of order. But of course things have changed dramatically in South Africa today. The new democratic dispensation, in terms of its 1996 constitution, not only allows but directs courts to refer to international human rights norms. And so today, wonder of all wonders, South African courts do refer repeatedly to international human rights norms. And I think Arthur will agree with him when I say that it is quite amazing the way in which South African judges brought up in another tradition have adjusted to the new system. The 1996 South African Constitution not only protects political and civil rights, but it also guarantees or recognizes social and economic rights, right, to health, to housing, to water, to food, to work, etc. This is a novel feature of a constitution, but it does mean that the South African courts can now refer to the International Covenant on economic and social rights in addition to the Covenant on civil and political rights. And this has become a great issue in South Africa, the extent to which courts may review the policies of the government in respect of the provision of social services. And one case which has received considerable publicity in recent times, which my daughter Jackie has been involved, concerned the issue of the provision of water. The issue was whether the government, the local authority, was taking reasonable steps to provide water to poor people in the Johannesburg area, or whether the court should quantify the amount of water that should be made available. And it was argued that the Committee on Economic, Social and Cultural Rights had laid down a minimum cause standard which should be applied. The courts have not accepted this. This does indicate the novel feature of the South African Constitution. Other countries have a long way to go before they allow courts to determine the question of whether governments are providing adequately in respect to social and economic rights for their people. The second question that I wish to address concerns the issue of accountability. International law is no longer satisfied with simply a declaration of standards, standard setting, but it's also determined to hold those responsible for human rights abuses accountable for their sins and crimes. We do have the International Criminal Court and a number of ad hoc tribunals that have been established in order to try people who commit international crimes, violate international human rights standards. But it is also possible for national courts to hold people accountable for the violation of international crimes and human rights standards. First of all, there is a possibility of criminal prosecution when a state court exercises universal jurisdiction over a crime committed anywhere in the world. But in the United States we have a wonderful statute, the Alien Tort Statute of 1789, which allows an American federal court to exercise jurisdiction over an international tort, an international wrong committed anywhere in the world. This is a statute which was only resurrected in the early 1980s, but in recent times it has been used to prosecute individuals and corporations who have aided and abetted human rights violations or have committed human rights violations outside the United States in many parts of the world. So the United States court system has become a procedure which allows for international accountability. And as you can imagine, many of the cases have been brought against corporations that have aided and abetted the governments in the denial of human rights. And this is a very controversial issue at present because recently the U.S. Second Circuit Court of Appeals has declined to exercise jurisdiction over Shell in respect of human rights violations in the Niger Delta. And the Second Circuit Court of Appeal has held that only individuals can be held responsible and accountable, not corporations. And this is, I believe, a major step backwards. And I think that what I fear about the United States is that this tension between those who favor recourse to international law, judges who favor recourse to international law, and those who are against it. Tim has referred to a number of the cases in which this has happened, is manifesting itself in the interpretation of the Alien Tort Statute, because we do find that American courts, which are generally much more open to arguments under the Alien Tort Act, have now held back, taken a step back, and started to invoke strange doctrines of sovereign immunity and strange interpretation of the law in order to restrict the scope of the Alien Tort Act. And I would simply like to say that, in my view, this is one of the great features of American jurisprudence. It does allow an American federal court to hold persons accountable for egregious human rights violations committed anywhere in the world, and I do hope that the courts will not restrict its scope. Thank you very much.
Well, thank you very much. I'm going to invite some questions for a moment, but listening to the talks, there were two things which struck me, and that is listening to stories from Australia and America. John and I come from the same country, so our stories are the same. But how similar facts can be. Because we had a case much like the one that Michael Kirby talked about, but it had a different result. It was about one of the very few then African attorneys allowed to practice was appearing in court, and the magistrates were very upset at his presence. And then after a while, they decided what they would do is they would establish a separate table in the courtroom. And so when he arrived, they said, no, that's a table for black lawyers. Everybody else sits there, but black lawyers will sit here. And he refused to sit at the table, and he was ultimately convicted of contempt of court. And there were a series of appeals, and regrettably, unlike the Australian High Court, our highest court at that time said, well, it's a matter for the judge, the judicial officer, to regulate. And so the conviction of contempt of court was upheld. But in some mysterious fashion after that, the tables were moved.
Part of the journey.
But it was quite a disgraceful judgment. As far as land was concerned, we had much the same thing. The great majority of the black people in South Africa lived in communal areas, initially known as reserves, later on called homeland, brings in the whole question of language and euphemisms, how to use a nice word to describe something quite awful. And the president of the country was the supreme chief, the white president was the supreme chief of all blacks in the homeland, and had plenary power to make laws applicable. So what happens in South Africa happens in America, happens in Australia, happens in South Africa.
Settler societies, they have a lot to learn from each other and others.
And the law didn't, perhaps the law will grow to be able to deal with them all in an equitable fashion in time, and hopefully that is happening in South Africa now. Yes, I'm going to, I know some of your names and I don't know all of your names, so I'm going to point at everybody to be equal.
This panel is composed by 4 eminent jurists of 3 major common law countries. And it is from a European viewpoint. It is curious to see how the common law systems coincide, that the treaties that the countries ratify are not directly applicable. In Europe, after the Weimar Constitution in Germany of 1919, it is considered that generally recognized principles of international law are part of the federal law and therefore directly applicable. And so the Constitution in Spain or the Constitution in France and even the Constitution in Holland, if I remember correctly, says that treaties are even above the Constitution itself. So how would you consider this, let's say, continental European position of accepting this monist attitude vis-a-vis what you have explained from a common law viewpoint?
John?
Well, I think you're talking about a position that prevailed many years ago. In some common law countries, the situation has changed dramatically. For instance, in the case of South Africa, we have a constitution which actually directs the court to apply customary international law and to makes provision for the incorporation of treaties and obliges courts to interpret the law in accordance with international law. And South Africa is not unique in this respect. One finds that much the same has happened in England. It refers to the European Court, the European Convention of Human Rights is guided by it. I think it's true to say that the sharp distinction that did prevail between the civil law and the common law countries in respect of international human rights standards is no longer so sharp. I think that common law countries do invoke international human rights standards to a much greater degree. I think in the United States we perhaps a bit backward in this respect.
Could I just try to explain the fundamental basis of the common law position? It was that the executive government, the Crown or the President, negotiates and signs treaties, and that the lawmaker is the Parliament elected by the people, and therefore unless the Parliament elected by the people gives effect to a treaty, it's simply something the executive has done. And one of the great constitutional battles in the common law world was between the Crown and the Parliament. And this is how it developed. But the mistake that was made was that it wasn't fully realised until Bangalore that whilst Parliament is the main lawmaker, judges also have a role in making and developing the law. It can't be a matter of incorporating a treaty by the back door, as it's often said, but it can be a part of developing legal doctrine within the country by reference to the contemporaneous developments that are happening. So it wasn't entirely an unreasoned position of the common law. It was a position defensive of the elected parliaments, which were always very strong in common law countries. And what we've seen now is that the role of the judges has been enhanced. And I must pay a tribute here to Robert Post and the Yale Law School for organising every year a great conference of judges of constitutional courts all around the world for, as it were, telling them, as Justice Chaskalson said, the same things are happening all over the world at roughly the same time, so we can learn from each other. And I would hope for this law school, with Professor Bergenthal now returning home, as he said when he came back here, that it will also play a real leadership role in the United States of America, which, like my own country, is about the last resistant bastion of the old doctrine, so that judges realise they too have a role. It's not the great lawmaking role of parliaments. because we don't have the democratic legitimacy. But it is a role of developing legal doctrine, including, as the High Court of Australia did, in the field of Indigenous peoples' law.
Tim, you want to add anything?
Well, yes, but it won't really be much of an addition. One of the troubles in the United States about this position, as it's held, is that the State Department, the Legal Advisor's Office, in determining whether to support an international instrument, or whether to ratify or sign an international instrument, generally speaking, will make a review to determine whether that instrument is entirely consistent with the already existing United States law. Well, good heavens. That would mean once it's adopted, supported, or signed, it would have no effect at all. And that's really not appropriate in the case of human rights instruments, especially where indigenous peoples are concerned, because change is needed. And if they go about refusing to adopt anything or recognize anything that doesn't merely ratify existing law, well, that's quite contrary to the whole idea.
I think we're beginning to run out of time, but yes, we have a question there.
I make a question, an issue to the panel regarding Roma rights. As we all know, President Sarkozy has decreed the expulsion of Romas from France. Some of the other governments of the European Union differ from the position of the state in France. The Minister of the Interior of the current but mortal Italian government has also supported Sarkozy's position. This matter may become a justiciable matter, so to say, under the sort of immigration rules of the European Union countries. But it may also become a justiciable matter, and this is where we like to have the view of the panel under the what's called the human rights laws. And it may also develop into a conflict between laws in the positive sense, word, and human rights principles.
I can respond at least in part. I hesitate to respond with reference to the facts because I don't know enough of them, and that I should not respond about the facts in particular. However, I can point out that the Declaration on the Rights of Indigenous Peoples, for the first time in an extensive way, recognized that groups or collectivities or peoples have rights in international law. Now, many countries were perfectly willing to call those human rights. Other countries, and some scholars, don't like to call them human rights, but they all agree that they are actual legal rights in international law, and they've now been extensively recognized in this one document. And in principle, they should be recognized much more widely. That may be of some help. Rights against discrimination, of course, against the whole people, rights of against discriminatory treatment, even some rights of self-determination for peoples within countries, and so on. I think there's no question that these actions at least implicate international human rights issues, and we'll see whether the advocates take up those kinds of arguments. I hope they do.
I think we must face the fact that immigration has become a major issue in European countries today. And it's not only the Romas that are threatened, but there are political parties in a number of European countries, including the Netherlands and China, where Muslim people are under threat as well. So I think we have to face the fact that there is likely to be a confrontation between governments and the European Court of Human Rights on issues relating to discrimination in the application of immigration laws. And one simply hopes that the European legal order will prevail and that discrimination of this kind will be resisted.
Michael.
As you would know, the common first article to the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights refers to the people's right to self-determination. And of course the question then is, who are a people? And part of the reason for the former government of Australia resisting signature of the Indigenous Peoples Convention was a fear that that might endorse the notion that Aboriginal people in Australia or Torres Strait Islanders could exercise self-determination as against the rest of the country. But what isn't fully realised by some of the critics is that self-determination can take many forms. It doesn't mean necessarily, and in many cases it won't mean, complete national independence. It merely means fulfilling yourself, and fulfilling yourself by institutions, by language, by culture, and so on. The former government of Australia refused to sign and indeed voted against. It was interesting. Those who voted against it were New Zealand, a wonderful country and a very enlightened country that has treated its Maori people the best of any of the settler societies. The United States, Australia, and Canada. I mean, three rather good countries in terms of the way things normally happen, but they voted against them. Australia had a change of government, a big change of government, and the new government announced that it was going to ratify the convention. Hasn't done so yet, and of course it's been re-elected with a knife-edge majority, so it'll be interesting to see whether they do. But I expect Australia will ratify the convention.
Well, because of the question, I'm going to broaden the panel because we actually have an expert on that, just sitting there at this table from the Roma Rights Centre, and perhaps, Robert, you might just like to respond to that question. And can I just get an indication? I know there's strict time. Can you tell me whether we're finished, whether we've got any extra time we can claim? After.
This is it.
Right, well, you've got the grand finale.
Better make it good. I mean, I think that the issue of Roma expulsions in Europe very much illustrates the interplay between law and politics here, because on the one hand, what France has done in declaring a law enforcement and migration policy explicitly along ethnic lines, as the President of France and the Interior Ministry have done in written documents, is clearly a violation of international law. On the other hand, the French government has assessed the political cost of violating international law in this regard and decided that it's an acceptable one, and weighing domestic politics as well. And if you look at the broader set of European human rights institutions, we see this similar issue, that you have, on the one hand, a very well-developed set of international institutions, and the European Court of Human Rights is one of the premier adjudicatory mechanisms for international human rights laws expressed in the European Convention. On the other hand, enforcement and implementation of European court decisions leaves a lot to be desired. And essentially, European states frequently decide that it is part of the cost of doing business, of violating rights, to lose a case, to pay some very small money judgment to victims, and then to continue violating rights as they have before. And we see this certainly in the Roma rights context, where you have three decisions of the European Court finding that segregation of Romani children in schools constitutes illegal discrimination. But in all three cases, the governments concerned have paid off the small sums to the victims and continued segregating their schools. And France, I think we have a similar situation where France is, they're prepared to bear the political cost of the violation and continue behaving as they have.
Well, thank you. I'm sorry we've run out of time. It's a great pity because I think that we're getting on the brink of a very, very interesting discussion. But I'm subject to the rules. I've got no discretion to extend the time. With much thanks, and really it's just an opportunity to hear our laureates in action. I think you've heard them, you know who they are, and thank you all very much, and thank you for the questions that we've had. Thank you again to the Gruber Foundation for the occasion, for the prize ceremony, and for choosing such three splendid people.
Thank you all for joining us, and this does conclude our program.